that the school can claim protection only after the government declared it as a minority. We are not dependent on the declaration, Malaj. It's what happened antecedent to the declaration that will determine whether it's a minority institution or not. So whether the minister says it or the statute says it, none of that is relevant. What is relevant is the factual position existing antecedent. He's giving all kinds of examples. Land was given is completely wrong. But we are not into that. That's why I'm not arguing any of that. That's why I'm not even meeting that argument. Surely, Malaj, the minister's contradictory opinions can't be the basis of a judgment of a court. That certainly is settled law now.
You can't quote one part and not...
No, you're right. I'm not disputing that. I'm not disputing what you're saying. You will read the other part and I will read this part, right? Yeah,
Based on
that's all right. It is already on record.
It's not on record. We have placed the entire thing on record.
I see, but you haven't quoted it.
Anyway, let's
Send it as you haven't given it to us.
No, it's there in volume 4F.
We don't have it.
4F.
We don't have it. It's not uploaded.
It's there in the common file. Your nodal council has it. 4F. Let him say it's not there. They have it since then, since long.
No, Malaj, kindly let's move on with the message.
That's the better way. That's the better.
Debate is not in question. I'm just trying to give the Malaj, let's go back to what I was saying, Malaj.
72 amendment.
Yes.
That brings out, what exactly happened. It appears that there was student unrest on the campus.
Yes.
At that point, they brought in a temporary measure.
Yes.
The idea was to bring both Aligarh Muslim University and Banaras Hindu University at par in terms of the statutory provisions.
Right.
UGC appointed a commission chaired by Dr. P.B. Gajendra Gadkar, former Chief Justice of India, to go into the functioning of AMU. That Dr. Gajendra Gadkar submitted his report. We may have we may want to look at the report which was submitted by Dr. Gajendra Gadkar.
Sure.
On what did the report really indicate?
Right.
Following which, but the 1965 amendment was always intended to be a sort of a pro tem amendment until long-ranging amendments were brought into the provisions of the statute.
So then, Malaj, between 65 and 81, I go back to my list of dates, Malaj, the point of which is that volume 4.
See if you look at
note, yes. Then between 68 and 81, there was a movement to protect the rights of Aligarh Muslim University as a minority institution. And then the 1981 Act came. So you have a hiatus between 65 and 91, Malaj. 68 and 91.
Just give us the page number of the 1981 Act so that we'll have it all in one place now. Volume 4A.
4A. Volume 4A, Malaj.
Page?
Page 147. Malaj, minority school in paragraph 11, Malaj, your lordships will see, is defined in 2.5 of the Act. Minority school means school of their choice established and administered or administered by such minorities as have the right to do so under clause 1 of 30. Counsel for both sides conceded that there is no provision in the Act which enable the government to declare a school as a minority school. If so, a school which is otherwise a minority school should continue to be so, whether the government declared it as such or not. Declaration by the government is at best only a recognition of an existing fact. This is very important. Article 31 of the Constitution reads as such, I won't read it, Malaj. When the government declared the school as a minority school, it had recognized a factual position that the school was established and is being administered by a minority community. The declaration is only an open acceptance of a legal character which should necessarily have existed antecedent to such declaration. Therefore, we are unable to agree with the contention of the school that the school can claim protection only after the government declared it as a minority. We are not dependent on the declaration, Malaj. It's what happened antecedent to the declaration that will determine whether it's a minority institution or not. So whether the minister says it or the statute says it, none of that is relevant. What is relevant is the factual position existing antecedent. So this happened, Malaj, in November 81. The Act comes on December 22nd, 81. In the meantime, on the ground, nothing has changed, Malaj. when Chakra made that speech in Parliament, he didn't implement the 65 Act as that was thought to be done. He didn't do it. Only, instead of all it being packed, only 3-4 members remain of the non-Muslim, of nominees of the government. Then, that is the Old Boys Association, which was set up in 1899, started a whole movement that, look, this is all wrong. This is all wrong. You must have an act. That's how the act came into being. And I mean, I don't want to digress into any other issue, but the fact is that this is a pre-Constitution Act. It's a 1920 Act. Without going into usurpation of judicial power, that's all, according to me, an irrelevant issue. Under 372, an act can be repealed, altered.
One act.
Yes.
Did that have the effect of, therefore, then nullifying the 65 amendments?
Yes. Yes. Absolutely. So this whole argument of usurpation, the Constitution gives the Parliament that right. But I don't want to argue it because it doesn't arise in Bhasha. But since,
Bhasha involved a challenge to the 65 amendments.
That's right. And 51.
And 51.
Yes.
And the 1981 Act then restored the position by, I don't know whether it destroyed
it didn't exactly restore. It was a new legislation.
But it nullified the effect of the 1965 Act.
That's correct. But that doesn't matter because the 372 gives power to Parliament to alter a law.
If we, will it be correct to say?
It seeks to nullify the judgment.
No,
No. That's not true.
I'll show. I'll show.
Will it be correct to say that in case we overrule Bhasha, then the challenge to the 65 amendments will come into the foray?
No, the point I'm making is somewhat different, We are challenging Bhasha on the day when it was decided. Therefore, none of this is relevant, according to me. Because the reference is only whether Bhasha was rightly decided on the day it was decided. That's the reference. But all these matters are now being brought in by the other side. All these matters saying it's an institution of national importance under. What to do is whether Bhasha is rightly decided or not. On the parameters of the law under Article 30. What your lordships are not asked to decide. Now they have brought in entry 63, it was not argued in Bhasha. Are we to argue something else now? They brought in statutes that are minority statutes that are normal institutions that are now incorporated under the National Minority Commission Act. Are we to look at that? That's all irrelevant. Wholly irrelevant. This is a decision of 1968 based on an act of 1920, which your lordships are asked to decide whether it's right or wrong. Otherwise, there'll have to be pleadings because he has made some amendments which are completely wrong. But you can't have pleadings in a reference. He's giving all kinds of examples. Land was given, it's completely wrong. But we are not into that. That's why I'm not arguing any of that. That's why I'm not even meeting that argument. But that whole argument is sought to be diverted to issues which are not before Bhasha, issues that don't arise under the 1920 Act.
Well, what else?
So, I'm quickly trying to go through it. So, no. Then what happened was, just kindly, I'm trying to finish as quickly as possible.